A very good morning and welcome to the 14th meeting of the Criminal Justice Committee in 2025. We have apologies this morning from Pauline McNeill and Fulton McGregor, and Sharon Dowie is joining us online. So our first item of business today is an opportunity to put questions to the Scottish Government on the following negative instrument, and that is the Coronavirus Recovery and Reform Scotland Act of 2022, Savings Provisions Regulations of 2025, and that's SSI number 2025-101. So this is a negative instrument which is scheduled to come into force on the 30th of November this year. And I refer members to paper 1, which sets out the purpose of the instrument. So we're joined this morning by Angela Constance, Cabinet Secretary for Justice and Home Affairs, and Patrick Down, Criminal Law and Procedure Team Leader at the Scottish Government. So welcome to you both and thank you for joining us. So I wonder if I can just invite the Cabinet Secretary to say a few words about the purpose of the SSI. Cabinet Secretary.
Thank you, Convener, and good morning to colleagues. I will just say a few words. The Coronavirus Recovery and Reform Scotland Act 2022 Savings Provisions Regulations 2025 are intended to ensure an orderly transition back to the pre-pandemic criminal procedure time limits that apply in solemn criminal cases. They implement the recommendation made by this committee in its Stage 1 report on the Criminal Justice Modernisation and Abusive Domestic Homicides Review Scotland Bill to put in place saving provision for those criminal procedure time limit extension provisions which will expire on the 30th of November this year. The two time limit extensions provisions that remain in effect are those relating to the time within which a solemn trial must commence where an accused has been remanded in custody, which was extended from 140 days to 320 days, and the time within which a trial must commence after an accused first appears on petition, i.e. the bail time limit, which was extended from 12 months to 18 months. This order preserves the extended time limits in place for any case where an accused first appeared on petition or was first fully committed before the extended time limits expire on the 30th of November. It will avoid a situation where the Crown Office and Procurator Fiscal Service require to either indict a very large number of cases or seek to extend on a case-by-case basis the time limits for cases that would otherwise all become time-barred on the 30th of November this year. And the consequence of this would be diverting resources away from managing other court business. It will also allow the reversion to the pre-pandemic time limits to be managed over a period of months. This approach has been agreed with the Crown Office and the Scottish Courts and Tribunal Service, and it's also in line with the approach that was taken when the extended time limits for certain summary-only offences were expired on the 30th of November last year. Convener.
Thank you very much, Cabinet Secretary. So I'll now just open up to members for questions. I wonder if I can maybe just come in just on that final point that you made with regard to Crown Office and SCTS, and obviously we're aware that this has been developed with them very much involved. I just wonder if you can just maybe just expand a little bit more on their view of the SSI and if it will meet their needs going forward, which obviously it will, but beyond the timescale that obviously we're looking at today.
Yes, so that's my understanding. And when I last met with the Lord President and the Lord Justice Clerk, this was a matter which we discussed, and the Chief Executive of the Scottish Courts and Tribunal Service was also part of that discussion also. And of course the Crown Office have been very transparent in their views and made a number of representations to committee, and my officials have engaged very closely with Crown Office. And also bearing in mind that the approach that we're taking to ensure an orderly transition isn't novel. It is one that we have done with other time limits, just to ensure that we revert back to pre-pandemic time limits, but do so in an orderly fashion, avoid that cliff edge, avoid cases becoming time barred, and actually avoid the Crown Office having to either, proceed with a high volume of cases at once, or indeed the issue that we've discussed a lot in this committee is having to, on a case-by-case basis, seek time extensions, which is just a massive drain on resources. So I'm confident that stakeholders and our partners are supportive and comfortable, and that this is just pragmatic and sensible about ensuring that orderly transition.
Thank you for that. Okay, thank you. So I'll open it up and I'll bring in Liam Kerr.
Very grateful, Convener. Good morning, Cabinet Secretary. I'm absolutely comfortable with the SSI. However, this committee has heard from the Scottish Solicitors Bar Association, the SCTS and the Law Society of Scotland that the courts aren't going to be ready to return to pre-pandemic time limits. Does the Scottish Government accept that? And if so, how are you as Cabinet Secretary going to support that return to the pre-pandemic limits? And do you think they will be ready by November?
Of course, the majority of the coronavirus time limits have actually been expired, and we just are now left with the two solemn time limits. So this SSI in front of us today is dealing with the remaining two time limits out of the original 7 time limits. So that journey has already commenced. I am acutely conscious that every time I have came to committee to seek an extension on the coronavirus regulations, the area in which committee has pressed me most on is the remaining time limits. And of course, we've all known that the coronavirus legislation was going to come to an end. But I hope the progress that has been made with the court backlog, the number of scheduled cases actually has reached a milestone in that it's now less than 20,000 cases. You will remember that at its peak, the number of outstanding scheduled cases was in excess of 40,000. So the court backlog has been reduced by over 50%. So there's progress been made, and stakeholders, both the court service and the Crown Office, who we have had extensive engagement with, are content that that the system will manage with this.
Can I just push on, because I think that last point was the answer to my question. I'm just concerned because the committee has heard from these 3 separate agencies that they are concerned that the court system won't be ready. But I think what I was hearing in your final sentence there was the engagement has been happening, and perhaps that information that the committee has is now out of date. Is that roughly where we are, and the courts will be ready?
Well, I can't comment about what evidence committee has received. I can only tell you that the evidence that I have received, and that's from engagement with the Scottish Courts and Tribunal Service and the Crown Office, which has been direct engagement between myself and my officials, and I have not had any red flags raised to me. And I would be confident that either the Crown Office or the Scottish Courts and Tribunal system would not be shy in raising any red flags with me.
I'm grateful.
Thank you. And Katie Clark.
I warmly welcome that the Cabinet Secretary is bringing these regulations forward today, and she has our full support, our strong support in trying to ensure that we get back to the old time limits. And what she seems to be saying is the advice that she's being given is that this is all very achievable. However, I'm sure it's not without its challenges. So will she keep the committee advised of any difficulties and how they can be addressed to ensure that we actually do meet this deadline and that we're able to deliver on what we're likely to vote for today?
The short answer would be yes.
Thank you.
Okay, thank you very much. Okay, if there are no more questions, thank you very much. So our next item of business today is to formally consider the negative instrument that we have just discussed. So can I ask whether members wish to make any recommendations in relation to this negative instrument? Otherwise, are we content that this comes into force? So thank you very much. And we'll just confirm with Sharon Dowie. Content? Thank you very much. Okay, in that case, thank you very much, Cabinet Secretary and Mr Down, for your attendance today. And we'll just have a brief pause while we have a changeover of witnesses. Thank you. Just short suspension. Thank you. Okay, thank you very much, members. So, following the signing of the Trade and Cooperation Agreement between the United Kingdom and the European Union in 2020, the committee asked our colleagues in SPICE and the Scottish Parliament Academic Fellowship Programme to undertake a piece of research work. And the aim of this research is to assess the actual impact of Brexit on Scotland's criminal justice system and our coordination and cooperation with EU member states. So 2 members of the Academic Fellowship undertook this research and published their findings in September 2024. And I'm very pleased to say that they are here today to give us an overview of the evidence on that work. and they will highlight the areas that they believe the Scottish Parliament and Scottish Government should look to work with the UK Government on to improve the way that the Scottish criminal justice system and policing interacts with the EU under the Trade and Cooperation Agreement. So I refer to members to paper 2, which sets out the findings and recommendations of the research, and that paper also contains links to the main research report and to the presentation that we're going to receive this morning. So a warm welcome to Gemma Davis, Associate Professor of Criminal Law at Durham University, and Helena Farrand Carapico, Professor of International Relations and European Politics at Northumbria University. So you're both very welcome. Without any further ado, can I invite Gemma and Helena to give us a presentation on their research work, and then after that we will open up to questions. So over to you.
Thank you so much. Good morning to all the members of the committee, and thank you to the Criminal Justice Committee for commissioning this report and for the opportunity to present this oral evidence. It is a real pleasure and honour to actually be present here today. The report, as the convener mentioned, was commissioned through the Scottish Parliament Information Centre in the format of a fellowship that aimed to explore the impact of the implementation of the TCA on the Scottish criminal justice system. The data in the report, as you might have read, is based on 23 interviews conducted with Scottish criminal justice practitioners and on a roundtable with 14 practitioners as well. Today's presentation will therefore focus on cooperation, how cooperation has continued to take place and what operational challenges have emerged since the TCA has come into force. Overall, the purpose of this presentation is to provide the Scottish Parliament with the knowledge necessary to better shape outcomes for Scottish criminal justice. Specifically, the presentation is going to focus on 3 elements: access to EU agencies, access to EU databases, surrender and extradition, and it concludes by offering recommendations and discussing the outlook for the reset of UK-EU relations. Although the report focuses on the Scottish reality, the operational deficit does apply to the rest of the UK, and so we therefore highlight recommendations for both the UK government and for Scottish officials. We would like to start just by outlining the pre-Brexit situation. We will obviously go very fast in this section, given that we have limited time. For this section, we just wanted to mention that during its membership, the UK relied very heavily on EU policing and judicial cooperation instruments. And it did so on a selective basis, on a series of opt-ins and opt-outs that were actually part of EU treaties, and that this regime, the selective regime, was particularly aligned with the UK's national interest. The TCA has provided, indeed, a very important degree of continuity. However, there are some notable losses in capability that have emerged. And so the next slides, as we will present, will focus on understanding what those losses have been and how they can be remedied. We will start with access to EU agencies. So the TCA does provide continued access to Europol and to Eurojust, which has been unanimously recognised by our interviewees as being crucial to their work. However, there has been a noticeable reduction in strategic influence as well as access to critical information. We will focus specifically on Europol, given the time limit that we have. So since the entry into force of the TCA, the UK has indeed established the largest third country liaison bureau at Europol, superseding that of the United States, which has been considered to be necessary for robust cooperation to continue to take place. However, there's been a loss of capacity, a loss of operational capacity, namely in terms of there's been no participation of the UK in the management board, so no capacity of the UK to shape the future EU instruments in development, to shape the work of the strategic work of Europol. There's been no British police officers serving in Europol's operational and analysis centre, in the sense that there's been there is a loss in terms of knowledge that actually goes into these operational centres from the UK to Europol, but also that then would come back to the UK at a later stage. And we no longer have direct access to Europol's information centre. information system. It means that in practice there is an indirect access where the UK officials actually have to ask Europol whether there is specific information contained in that system that could be relevant to ongoing police operations, and then Europol does provide or not that information. Finally, we are no longer allowed to actually lead on Europol operational task force. That means that we need a supportive member state that actually understands the UK's priorities and actually is able to initiate a task force for the UK that we then can take part in. Overall, relations with Europol continue to be absolutely excellent, but provide reduced access and are more resource intensive in terms of number of police officers involved, amount of time, amount of process. We highlight only a couple of recommendations in this slide. Obviously, the report provides a lot more recommendations, and the two recommendations are regarding access to further EU Justice and Home Affairs agencies. So, as we mentioned, we have access through the TCA to Europol and to Eurojust, but there are, however, a lot more Justice and Home Affairs agencies that could be of interest to the UK and in particular to Scotland. So that's the case, for instance, for the European Drugs Agency and for ENISA, which is the Cybersecurity Agency. In terms, the European Drugs Agency actually collects, it's more of a scientific agency, it collects information on the circulation of an emergence of new drugs on the market. So thinking specifically about Scottish priorities in terms of the drugs markets, actually access to European Drugs Agency would be very helpful. And in terms of the Cybersecurity Agency, obviously it goes beyond Justice and Home Affairs to other areas of foreign affairs, but it still actually would be of relevance in terms of coordinating the positions of cybersecurity and actually highlighting new cybersecurity threats that actually have emerged. The TCA in Part 4 does give the possibility in the future of agreements with ENISA, but it does not exist for the moment. Finally, the last policy recommendation for this area is, despite the signing of the TCA, there are some EU member states that still have domestic legislative impediments to police cooperation. That's the case, for instance, in terms of sharing evidence. And so a lot could be done in terms of actually working with these EU member states to actually identify those domestic impediments and actually addressing those. In terms of access to EU databases, so the TCA does provide quite a lot in this area. It does provide access to DNA, to fingerprint exchange, to vehicle registration data, passenger name records, and criminal records. That is, it mirrors very much what we had access to before in terms of Prüm. However, there's also been a noticeable reduction in access to some critical information, and we have highlighted 4 different areas. The first one is access to the Schengen Information System 2, which is considered still the largest EU law enforcement database. The UK has lost access to it in its entirety. Not only that, but the data that the UK used to hold from the Schengen Information System had to be deleted, and the UK is no longer able to benefit from any future enhancement to the system. In practice, the UK is fully dependent on EU member states to upload law enforcement notices or important information to the Schengen Information System 2. Those member states have to double key that information into the Interpol global database called I-24/7. So they have to do the double of the work so that the UK benefits from that. Thinking about the 3 other areas, so in terms of vehicle registration data, we will just highlight the areas where there are actually deficits. So the cooperation system for the vehicle data is still not in place, and this has to do simply with lack of technical preparation on the side of the UK. In terms of criminal records, we do have access to criminal records, but we are not going to have access to an instrument that is actually going to be coming very soon, called the ECRIS TCN, which is the European Criminal Record System information for third country. So if there is a third country national in the EU that has committed a crime and has gained a criminal record in a EU state, if that person then moves to the UK, we do not have access to their criminal record at all. Finally, in terms of passenger name records, we do have access to passenger name records, but the UK is actually now required to delete that information once the passenger leaves the UK. So obviously that has an important impact on future police operations that may require that information. In terms of policy recommendations, in this case for the UK government, we would really recommend that actually the necessary technical capabilities be developed in terms of sharing vehicle registration data with EU member states, that we try and negotiate access to the ECRIS TCN system. And finally, in terms of interoperability, this is particularly relevant. There are quite a number of current proposals to the way databases in the EU actually work. This is not just in terms of expansion of collected data, but also how that data is shared and interconnected. And these proposals would actually require an important discussion to take place within the UK in terms of the fact that actually there are certain aspects of this data sharing that will impact on devolved areas. So if we think, for instance, in terms of access to DNA, or very much in the future, soon in the future, in terms of access to facial recognition through Prüm 2, which is currently in the process of being implemented, these future changes would actually involve discussions, for instance, with the Scottish Biometric Commissioner. And now I would give the floor to my colleague to actually focus on surrender and extradition.
Thank you. First of all, just in relation to the use of the terms surrender and extradition, they refer to the same process, but within the European arrest warrant, because it was a streamlined version of extradition. It's referred to as a process of surrender, but it does mean the same thing. So firstly, the UK significantly benefited, as did Scotland, from the participation in the European arrest warrant, and it was perhaps the most well-known of all of the EU cooperation tools. On the face of it, the provisions of the TCA providing for surrender do appear to quite closely replicate the features of the European arrest warrant. But there are a number of important differences, and on this slide here I've highlighted 4 key differences. The first is in relation to the ability of a member state to issue a declaration that they will refuse to extradite for non-violent offences which they consider to be political or related to political offences or inspired by a political motive. There are 12 member states that have chosen to sign that declaration. It's not available in the European arrest warrant, it is in the TCA. To date, there has not, to my knowledge, been an example of an individual that the UK sought to surrender from an EU member state that's been refused on that ground. However, what has had a much bigger impact is the ability to provide for conditions that a state would refuse to extradite its own nationals, either completely or under certain conditions. There are 13 member states that have stipulated some form of condition that would amount effectively to a nationality bar. So, for example, Germany has done so. And so if the UK seeks surrender of a German national, Germany will not surrender that national to the UK. In addition to that, there is also case law of the Court of Justice of the European Union, which means that even if a German citizen were to move, for example, to France, and a warrant had been issued by the UK to France, France would then first get in contact with Germany to give Germany the opportunity to issue a European arrest warrant. And only if they do not do so would it then respond to the warrant from the UK as a third country. The third difference is the requirement to ensure that there is dual criminality. So in the European arrest warrant, there was a list of offences for which dual criminality was assumed. So certain types of conduct where it was assumed that there would be dual criminality. The same list also appears in the TCA. and 12 EU member states issued a notification to say they would apply that list as they applied in the European arrest warrant. But the UK has chosen not to do so. Because the requirement of dual criminality has to be reciprocal, that means that even though those 12 member states said they would apply the list, that cannot happen. And so in all cases between the UK and EU member states, dual criminality must be established. In the vast majority of cases, that does not cause a problem, and usually dual criminality, the fact that, for example, that it's a crime both in the UK and in the state and in the other state, is not a problem. But the fact that dual criminality has to be assessed is an additional legal hurdle and a possible delay in proceedings as that is being considered by the courts. Finally, in relation to human rights, amongst EU member states, there is a principle of mutual trust and recognition. The Court of Justice of the European Union has made it clear that the UK does not benefit from mutual trust, which means that because the UK is no longer a member state, the judicial authorities in EU member states, when dealing with requests from the UK, must carry out their own independent assessment of the UK's compliance with the European Charter of Human Rights, which is very similar to the European Convention of Human Rights. And that has resulted in an increase in requests of judicial authorities in EU member states for assurances from the UK and from Scotland in relation to prison conditions, particularly in relation to prison conditions. In relation to policy recommendations, there are a few which I would wish to highlight. It has been possible for the UK government to negotiate with other states to try to deal with or eliminate some of these bars. A good example of where that's occurred is with Poland, where initially there was a nationality bar which prevented the UK from extraditing Polish citizens from Poland. There has now been an agreement between the two, and there has been changes to Poland's domestic law. So it demonstrates that it is possible for negotiations to be able to achieve some benefit. That is not possible in all states, because sometimes there might be, for example, a constitutional bar which prevents that occurring. However, one of the recommendations is that we have to continue to do that, to see where it may be possible to eliminate bars bilaterally. In relation to dual criminality, we recommend that the UK reconsiders its position. So that would provide, the dual criminality would provide some form of protection to those from the UK which are sought from extradition to other EU member states. But we think that there are very few cases where it is actually applying to prevent surrender or extradition. But on the other hand, it might be causing unnecessarily delay and complexity, and can be an example of where we can streamline our processes to ensure we make full use of the provisions of the TCA. In relation to prison conditions, we recommend that there is a very clear process for doing that, for who in Scotland would be issuing the assurances, and to ensure that that happens in as swiftly as possible, and that the prison estate meets European Convention of Human Rights standards and therefore minimises the risk of refusal on that basis. We also recommend that there be a negotiation on the transfer of proceedings. So in cases where the UK or Scotland is unable to surrender from an EU member state, there are a couple of options or workarounds that can happen. One is that you can issue a warrant to other states in the hope that that individual will move. The other is that you can transfer your proceedings formally to that state, and the individual can be prosecuted there. At the time of interviews, there were a small number of cases where that process was attempting to be conducted. It is time-consuming, it is costly, and an agreement between the EU and the UK setting out some of the boundaries of when that might happen, who pays for certain aspects of it, what translation is required, for example, what the evidential requirements are between the two, could help to smooth that process. And finally, we also believe that an agreement to facilitate transfer of prisoners would also help. That could maybe allow states to surrender individuals temporarily for them to return, which can happen. And we can transfer prisoners, but without a formal agreement, that becomes a much more cumbersome process. Finally, in relation to surrender, one of the primary differences is in the way in which a warrant is issued and how that warrant is circulated. That's very important because you can have a warrant, but if it's not executed, it has not served any purpose. And there are really two very significant differences between the European arrest warrant and a warrant under the TCA. So if we look at the European arrest warrant, that would be, if the UK were to issue a European arrest warrant, that would be issued to all EU member states at the same time, and vice versa. Any warrant issued by an EU country, such as France, would also be issued to the UK. The process now is that for EU member states, when they issue a European arrest warrant, that's not also issuing a warrant under the TCA. They have to issue, in addition, a TCA warrant. And in many EU countries, they will only do so if there is a clear connection to the UK. So frequently, an EAW will be issued and there will be no TCA warrant.
Yeah.
Secondly, previously the European arrest warrant was circulated via the second generation Schengen Information System, SIS2. All frontline officers have access to SIS2. The warrant, the warrant isn't issued, but the notice, the fact that somebody is wanted, can be uploaded to I-24/7. But frontline officers in EU member states do not have access to I-24/7. And therefore, those two differences mean that the consequences are, if that somebody is wanted from Scotland, it is much harder for them to be identified unless Police Scotland have developed very high-quality intelligence and know where the person is and then can work with police in France or wherever it may be. But the issuing of a warrant itself is unlikely to result, much less likely to result in surrender than it previously was. There are examples in the report at page 29 and 30 where we've given some worked examples of how that might operate. And so some of our recommendations are that the UK could negotiate amendment, for example, to the TCA, so that TCA warrants could be issued at the same time as a European arrest warrant is issued. Secondly, that a warrant issued by the UK, a TCA warrant, could be uploaded to SIS2, for example, we suggest by Europol. So not directly, because we can't directly have access, but indirectly that could occur. And that would mean that those warrants were available to frontline officers and could also provide an immediate power of arrest. Finally, we're just wanting to turn to look at, we have talked about recommendations that are about negotiation with the EU and therefore are for the UK government, but there are issues which are addressed in the report which can be dealt with by Scottish bodies or officers, and we deal with some of these here. So the first is to ensure that Police Scotland and COPS, the international cooperation units, have the needed personnel and funding and training required to keep the public safe. It is clear that post-Brexit there are processes which are much more manual, much more time-consuming, and therefore it's important that those units have the ability to develop the intelligence that's needed to ensure that Scotland is kept safe. There was, at the time of the interviews, a backlog of extradition cases. Cases are only heard at Edinburgh Sheriff Court. We've also talked about transfer of proceedings, and whilst there could be an EU-UK agreement on transfer of proceedings, we also think that there could be domestically a clearer framework for how and when we seek to transfer cases, to make sure that decisions are made fairly, that resources are available when appropriate to do so, and that is done consistently across different cases. So, for example, dealing with when there may be vulnerable witnesses, how would that, for example, impact a decision to transfer proceedings or not? We've also mentioned that ensuring the prison state meets ECHR standards. And then we've also talked about the enhancement of HMG's consultation with Scottish bodies when negotiating bilateral and multilateral agreements, including perhaps enhancement of the Scottish Parliament's scrutiny of the Partnership Council decisions. The Partnership Council is the body which manages the TCA and oversees the specialised committees within them, which would include, in this case, the Specialised Committee on Law Enforcement and Judicial Cooperation. There's currently no formal mechanism for scrutinising that work. There is also the EU-UK Parliamentary Partnership Assembly, where there is currently no Scottish representation. We highlight in the report that there are examples of where Scotland had not been consulted in the development of bilateral agreements. These are agreements with other member states which pave the way for further treaties which might be able to enhance police and judicial cooperation with those states. Since 2021, there have been 24 bilateral agreements that are in different stages of development. And we recommend, because the way in which extradition and mutual legal assistance, so the way in which evidence is obtained from overseas, is distinct in Scotland, whilst the legislation is national, how those operate are distinct, that it's important that Scotland is able to ensure that it's represented.
Thank you. And as a conclusion to this presentation, we would just like to actually then discuss a little bit the outlook for the reset of UK-EU relations. So the TCA does foresee a first review of its legal text, which is to take place in 2026, and this would offer a very good opportunity to actually ensure that some of these recommendations are operationalised and seamless cooperation is actually improved. On the positive side, there is clear political willingness to do so on both sides to develop closer cooperation. So if we look at the report by the Council of the EU, by the Presidency from December 2024, it does highlight that actually it wishes to improve cooperation in areas such as counterterrorism, human trafficking, surveillance, cross-border cooperation. If we look at the Labour Manifesto, we see that actually it refers to closer law enforcement cooperation. The Minister for EU Relations also confirmed that the second of the three pillars for the reset of UK-EU relations actually focuses on the safety of citizens, which obviously covers criminal justice cooperation. And to cite Member of Parliament Nick Thomas-Symonds, one of the objectives is to actually share data in real time with Europol, which is designed to ensure that there is no place on the continent for criminals to hide. This quote is from January 2025. And as Gemma said, also on the positive side, since 2021, there have been 24 bilateral declarations signed directly with EU member states that actually are particularly ambitious in the area of law enforcement, going beyond what the TCA currently stipulates. And as such, the UK-EU summit on the 19th of May 2025 is set to provide a clear milestone for delivery. There are, however, a number of challenges that we'd like to highlight. The first one is that, despite obviously being quite positive, the EU has stressed the importance of full UK implementation of the existing not only TCA but also withdrawal agreement, and in particular in terms of the rights of EU citizens in the UK. There is also a recent history of political mistrust, which has definitely improved since the Prime Minister Sunak administration. but which continues to actually create some hurdles, which the Commission has highlighted recently. There are also a number of EU red lines in this field, which have been highlighted by the Presidency. That is, no access, no foreseeable access to the Schengen Information System 2, and no foreseeable access to leading joint investigation teams, so instruments which are funded through EU funding. And there is also a considerable limited interest in large changes to the TCA, which would actually involve reopening the negotiation of the treaty, as opposed to a smaller review of the treaty. In addition to these points, there's also been a slow progress towards transforming those bilateral declarations that we spoke to about in terms of transforming them into legally binding agreements. There is, for instance, an example of one of the agreements that had been announced in January 2024 with Belgium, but that agreement is still waiting to actually be enforced, signed and enforced. Finally, given the geopolitical situation at the moment, a lot of the focus is actually on defence. So we will see probably that the UK-EU summit on the 19th of May is going to actually discuss discuss defence issues much more than law enforcement. So it also draws away the political focus on issues that are related to justice and home affairs. We hope that this presentation gave you a good overview of the report. We only meant to highlight certain aspects which we find are most relevant. And I'm now going to give the floor to Gemma just to actually close the presentation.
Just very briefly, just to say that we have developed, there is a book which we have edited, which is to be published very shortly. Part of that, a section of that looks at the implementation of the TCA for specific fields such as immigration crime, environmental crime, the trafficking of human beings, which is able to go beyond what we were able to do in the report. But that is everything. Thank you.
More than happy to answer any questions you might have. Thank you so much.
Great. Thank you so much. That's been really, really interesting. I've learned a lot from both the report and the presentation this morning, so thank you very much for that. I mean, lots for us to think about in terms of the impact of our withdrawal from Europe. It's good to hear that there are still good levels of sort of cooperation between the UK and European member states within the TCA, but as you've outlined, there are some challenges in terms of information sharing, intelligence sharing, and I was very interested to hear about the issues with timely execution of warrants, which I'm sure we'll come back to. So I wonder if I can maybe just kick off with quite an open question, and then I'll open up to members. And I think, Helena, quite early on in your presentation, you spoke about notable losses in capability in terms of cooperation between Scotland, UK and the EU on judicial matters and policing. So I wondered if you could say a bit more about what has been the most significant of these losses based on, you know, the conversations that you had during the study, the interviews that you conducted, particularly with police officers and prosecutors. And I suppose to follow on from that, how much of an impact has that, or have those notable losses in capability had on our ability to tackle crime, and in particular the crime types that you spoke about, human trafficking, cybercrime and so on. So it's quite a broad question, but I'm interested to hear a wee bit more about that.
Sure. Yeah, it's fine. I can start. We can then add. Thank you very much for the question. So, in terms of notable losses in capability, if we actually were to pinpoint one specific instrument, it would be access to the Schengen Information System 2. So, as we mentioned in presentation, this is the largest database for criminal justice in the EU and probably in the world. And so it was the database that actually police officers had access to directly, and that allowed them to actually identify whether someone was actually being sought after in a EU country, for instance. And so it is a significant loss in terms of access to data that, despite mitigations, has not been fully compensated for. In terms of impact, or in terms of mitigations, our interviewees have actually highlighted the importance of other systems that actually were very useful. So, for instance, they all have highlighted the importance of the Siena system within Europol in terms of circulation of information. And that's been particularly important, although there isn't a complete access, so we don't have access to confidential data, for instance. But we do rely considerably on this system at the moment. In terms of impact, it is really difficult to actually identify the exact impact that actually this loss has had. It is, it's an attempt to actually have access to an unknown, a negative, an absence. So when we actually asked our interviewees, they had difficulty actually pinpointing exactly the amount of the loss that's been had. Not only because it is difficult to actually calculate an unknown, but also because a lot of the police officers, for instance, that actually used to have access to the Schengen Information System had then moved on to other posts, and so there is also an issue of institutional memory. I don't know if you want to add anything at this stage.
I would agree about the loss of SIS2. I think the other is the nationality bar. Again, there are not public figures in relation to how many individuals and in what type of cases we have been unable to surrender. There has been some evidence given to the European Affairs Committee, where there was some data was given by those within the CPS in relation to those. So they did give some evidence about figures of those cases where they had been unable to surrender. But inevitably, there will, from those 13 member states, there will have been individuals that are wanted for very serious offences that we have not been able to prosecute.
The evidence was provided to the House of Lords European Committee on the 11th of March, and the Crown Prosecution mentions that there's been a reduction in numbers of surrender to the UK, and that's often linked to the fact that actually EU member states now only surrender or only ask for an individual to be surrendered when they are absolutely certain that the person is actually located in the UK.
Mm-hmm. Okay. Thank you for that. Just a quick sort of follow-up question then, going back to Schengen. That's a pivotal system that we no longer can benefit from. So how important do you think it is that when it comes to the TCA sort of negotiations, that we strive to perhaps move closer to where we were in terms of access to that particular system? And do you think that is it likely that will be included as part of the negotiations? I know that's maybe a difficult question, but how important is it that that is a priority, if you like?
It is important that we seek to improve access to data, and certainly there have been attempts to do that. We do set out in the report the developments of iLeap, and there have been a number of different progression points in relation to trying to get iLeap to a point where it might replicate some of the features or compensate for the loss of SIS2. It is where we're still fairly far from being able to do that. It is certainly something that it should be strongly, I think, at the forefront of discussions. I think, number one, it's very important that we have evidence of the impact, so we can demonstrate that where we have been able to where there's been a loss of access to data and the consequences that that's had on both sides, for both the UK and for EU member states. Within, I think, EU member states, within policing, there's a very strong, I think, desire to be able to cooperate as best as they possibly can. But obviously, that at the political level, things are more can be more difficult. But the other thing to remember is that the Part 3 of the TCA sits within a trade agreement. That's quite unusual. I'm not aware of any other trade agreements that would also contain an agreement on law enforcement and police cooperation. Part 3 is really a snapshot. I think we described that in the report. So it takes a picture of what law enforcement and judicial cooperation looked like in December 2020. But that constantly moves. Technology moves on. Organised crime moves on, and therefore there's constantly this development of systems, renegotiation of tools or development of tools, and so we need ways of ensuring that we're not left behind. That cooperation between the UK and the EU keeps up with our abilities to share more and more information.
The example of Prüm 2 is particularly relevant in the sense that the EU has now it's now in force, that it's being implemented from a technical perspective by EU LISA, but it is unknown how that's going to impact the UK in the future. We know that actually our interviewees would like to have access to facial recognition technology, for instance, data, for instance, but how is that going to be done from a legal perspective? Would we need to actually reopen negotiations on the TCA? How much of a change would that actually involve? And would that be a simple review or a larger change? It still needs to be established.
Yeah. Yep. Okay, thank you. I mean, so much that we could ask follow-up questions on there, but I'll leave that for now. Thank you, and I'll open up to members, and I'll bring in Liam Kerr and then Ben McPherson.
Very grateful, Gavina. Good morning to you both, and thank you for your presentation. I'll put my question to Gemma Davis because it was something you spoke to in your presentation, Gemma. At page 8 of your report, at bullet 3, it says, poor prison conditions in Scotland have led to requests for assurances in extradition and surrender cases. This is causing delay in Scotland receiving wanted persons from overseas and increases the risk that extradition is refused. Now, the detail of that is at page 36, where you go on to say, increased frequency of challenges related to prison conditions. Now, that's going to be hugely concerning to read for this committee, as I think you're suggesting that conditions in Scottish prisons are raising human rights issues and challenges to extradition. Can you then tell this committee more about exactly what you're getting at there? What specifically are the issues? How big a problem is this? And what does the Scottish Government need to do, and by when, to address it?
So I think, firstly, I think in the report we were able to identify at the point of the interviews how many requests for assurances had been received. So they were relatively small in number, I think 3. So there had been 3 requests for assurances. Those court cases would be made public. My understanding is that those cases came from other EU member states where there were then requests for assurances. There may have been refusals to surrender at an earlier stage of proceedings, but ultimately, as happens in the UK, those are appealed and eventually surrender did take place. So assurances were able to be dealt with in those cases. So assurances provided the opportunity to still be able to surrender. But that is something that we hadn't been seen before. It doesn't, however, it's not only related to Brexit. So it would be fair to say that across all of the of EU member states, concerns about prison conditions have been on the rise. That's not only for the UK, that's also within EU member states. And this requirement to ask for assurances about the size of prison accommodation, for example, or other requirements about different aspects of prison life being required. But that in Scotland, that had occurred since Brexit. That is likely, one aspect of that is that we no longer benefit from mutual trust, and so there's this, the judicial authority has to go through this process every time of considering aspects of the European Convention of Human Rights. Prison conditions are one of those, and those had been raised in a number of cases, and therefore it would be fair to say that it is important that prison conditions meet ECHR conditions, because otherwise it can cause difficulties with surrender.
I'm grateful. I'm going to press you slightly because at your bullet point 3 you specifically say, because obviously this committee is about helping the Scottish Government to do its job, and you specifically suggest that we write to the Cabinet Secretary and Lord Advocate to highlight that, and I'll quote from you, poor prison conditions in Scotland have led to requests. So really all I'm trying to understand is what are the specific prison conditions that led to the 3 occasions?
Perhaps if I in one of those cases, I know it was in relation to something called slopping out. So it was something to do with, I think that what I would prefer to do is to follow up on that question after the committee, and I will follow up on those cases and say exactly what the concerns were in each case, rather than try and remember something that I've read several months ago, which I really shouldn't do.
No, that's perfectly fair, and it's just really so that we as a committee can get to the Scottish Government and say, listen, this is what these experts are saying.
That is absolutely right, and I should have had that information for you.
Don't worry. A second question to you, if you don't mind. Oh, of course. Yeah.
I can just add, we will double check, but if my recollection is correct, it has to do with the size of prison cells and with access to healthcare, mental health care in particular. But we will double check this for the committee.
I'm very grateful. That would be fascinating. A slightly related point, which again I'll put to you, Gemma, just because it was in your presentation. You talked in your presentation about human rights issues, and further down page 36, you say, for outgoing extradition requests, the Extradition Act 2003 includes an additional ground for challenging extradition, the possibility of contesting Scottish Minister's decision on the basis it's incompatible with the ECHR. This provision is unique to Scotland and it doesn't exist in England and Wales. So you go on to say that that provision adds complexity. Can you help the committee understand, does it bite? And if so, what are you recommending to us as a committee that we do? Do we note it but keep it as best practice, or actually are you recommending that we look to align with England and Wales?
That is, I wouldn't be able to make that recommendation because that wasn't something that we were seeking to do. It was more that we recognised that that was something that was very distinct about the Scottish extradition system, and therefore we made note of it in our report, but we didn't seek to, because it wasn't specifically related to the UK's exit from the European Union, we didn't seek to consider whether that was an appropriate difference or not. Firstly. And I think, secondly, one of the reasons why it's raised is because post-Brexit there is this greater consideration of human rights in extradition cases because of the loss of mutual trust, because we are now outside of the European Union, and therefore these issues become more pertinent in extradition surrender cases.
I understand. Very grateful. Thank you.
Okay, thank you. Ben McPherson, then Rona Mackay.
Thank you, Convener. Good morning, and thank you for both of your time and coming to give evidence to us today and for your submissions. During the process of Brexit, I was Europe Minister for the Scottish Government, and during that time, the Scottish Government created a number of papers under Scotland's place in Europe. And in June 2018, one of those papers focused on the Brexit impact on cross-border crime and cooperation. And it warned about the impact that the Brexit process and the withdrawal agreement as it was conceived then and was then signed would have an impact in terms of membership, a negative impact in terms of membership of Europol, the European Arrest Warrant, the European Investigation Order, Schengen Information System 2, participation in Eurojust and the European Protection Order. And I think from what you've said today, it's clear that these later in these later years since the Brexit agreement was signed and the process took place that we are in a worse position. I mean, that's what your evidence seems to articulate. Am I interpreting that correctly?
It would be correct to say that the report highlights operational deficits, and I think that is accepted, from all those that we spoke to. I think that has to be tempered by the fact that there is also a recognition that the TCA has played a very important role in continuing with cooperation and has worked very well in many different areas. So without the TCA, a lot of those consequences would have very much come to manifest. However, it was not possible to continue cooperation in exactly the same way as we had done. So that it would be correct to say that there are operational deficits. The question is how much those can be mitigated. Yeah. And there's 3 ways in which they can be mitigated. They can be mitigated internally by the UK by ensuring we are using the TCA to the fullest of its ability, by looking at our domestic legislation, domestic frameworks, ensuring proper resourcing, for example, can all make sure that we are able to counter some of those operational deficits. Secondly, we can look to negotiate bilateral agreements where possible to deal with some of those operational deficits. And then thirdly, to work with the EU to recognise where some of those are occurring and where possible to try to negotiate improvements to ensure that they have less of an impact.
Just to add that actually, when Brexit negotiations were ongoing, it was really not foreseeable that the agreement would be so positive in practice for the UK. There was a lot more concern that actually the operational deficit would be much greater. So in practice, we believe that the negotiators actually did a fantastic, superb job given the conditions. So it is important to consider that actually the UK does have the most important criminal justice relationship that the EU has. So it is with the UK. So it is the closest relationship with any third country. And so it is really important to actually acknowledge the good work that has been achieved and then consider what could be done from here onwards.
Yeah, I mean, I think that's fair to say that despite the political approach by the hard Brexit position of the UK government at that time, what the civil service negotiated has clearly been better than what many of us feared. However, and I appreciate you don't want to get involved in the politics here, but it's just helpful to and I think it's important for us to recognise that because of the Brexit outcome, we are in an operational deficit. However, like you, I'm interested in how do we improve that situation. So I think what you just said as a pivot there into, okay, so how do we continue to improve the operational situation was helpful. And in your report, you talk about there's a clear willingness on both sides to develop a closer relationship. That's a good thing. But what measures do you think the Scottish Government should prioritise that we might improve the way that police and prosecutors can cooperate with the EU that don't require changes to the current political agreements and which could be relatively easily agreed between the UK and the EU? And of course, following today's evidence, and we will think about what we recommend to both the Crown and the Government here in Scotland, but also we may want to liaise with our UK counterparts in their committee on how do we also play a part in pressing UK government to do more. So interested in any further thoughts you might have in that space. And then I've got one other question. That's okay.
So if we turn to those 3 areas where I said we could seek to try to address, firstly looking at our looking domestically at how we can ensure we're using the TCA to its fullest. So for example, sharing vehicle registration data, looking again at the dual criminality requirement are all examples of where it's possible within the current TCA to improve some aspects of cooperation. Also, it's important, as I have mentioned before, to ensure that we international cooperation units are properly resourced. Historically, I think international cooperation has been a sort of a siloed area of the criminal justice system, but increasingly we see that more and more cases have a transnational element to them and require use of these tools. And so it's an important area that we need to make sure is properly funded and staffed. Then secondly, working bilaterally, and certainly Scotland does that, and we have seen does that very well, in fact. So we heard repeatedly that Scotland goes out and meets with other EU member states to discuss problems in practice, and that's a really important way of trying to ensure bilateral cooperation without, or improving bilateral cooperation without having to seek amendment to the TCA.
3 points in addition to this. The Scottish Parliament could certainly discuss with the Scottish Government to ensure that actually the Scottish Government is involved in being consulted when bilateral agreements actually are negotiated and signed, to ensure that actually Scottish interests are taken into account.
Did you have any evidence that that's not happening enough?
From some of the interviewees, there is some evidence that actually Scottish involvement has been insufficient.
Mm-hmm. That doesn't surprise me.
We would certainly welcome any further evidence that you may collect on this matter.
Thank you.
Second point, the ability of the Scottish Parliament to scrutinise Partnership Council decisions within the TCA to ensure that they align themselves with Scottish interests, and furthermore also for the Scottish Parliament that there is appropriate representation of the Scottish Parliament in the UK EU Parliamentary Partnership Assembly, the extent to which we were not able to fully verify, and we would also welcome further evidence that you may have found on this, to ensure that actually there is representation of Scottish interests in terms of parliamentary relations as well.
Okay, thanks very much.
Can I just, before I bring in Rona Mackay, can I just ask a little bit about the Partnership Council, because that's a new body on me, and I'm just interested to hear a wee bit more. It's maybe outlined in the report, and I've maybe just overlooked it. Just to understand what the Partnership Council is and how we link with it.
Dana, would you like to address that on the Partnership Council?
So the Partnership Council has been created by the Trade and Cooperation Agreement, and it ensures the correct implementation of the Trade and Cooperation Agreement. It is responsible for the specialised committees within that within the TCA, one of them being the one that actually manages Justice and Home Affairs. It is responsible for identifying implementation problems and trying to address them within what the TCA actually provides for.
Thank you. I've just looked at my notes and I see that you did include it in your presentation, so just my oversight. Okay. Ben, did you want to come back in, and then I'll bring in Rona?
Thank you. And apologies if this is slightly broader than your remit, but I am very interested if you do have any insights on this point. You may or may not be aware that in Scotland, Central Scotland particularly at the moment, there's some challenges that Police Scotland are working very hard to address successfully in recent weeks with regard to organised crime and its connections with the United Arab Emirates. And I know from further research that I've undertaken personally that, not as not academic research in the way you have, but that this is an issue that's facing the European continent as well as us here in the UK, about how our criminal justice system seeks to address organised criminals that are operating out of the United Arab Emirates. And I wondered if the research that you've helpfully brought to us today and elaborated on has thought about that wider dimension, particularly with regard to surrender and extradition that you talked about.
There is one area where I think we highlight in the report that international cooperation is always a moving feat. So there are different states which are important to cooperate at different times, and that can change very rapidly, and that can cause difficulties because relationships might not yet have been fully established with a particular state. But that is where Europol can also become very helpful, because often if the UK is dealing with a particular non-EU state, often there will also be other EU states that equally are experiencing the same difficulties, and therefore being able to use Europol can help with cooperation even in the United Arab Emirates or in other states. So I think to that's the extent to which the research that we did addresses that. I know that's indirect, but that cooperation with Europe is also very important, even for organised crime links outside of the EU.
Exactly.
In addition to that, we did uncover an element that is relevant to that question as well, which has to do with, obviously, the EU does sign agreements with third countries in terms of addressing organised crime, for instance. There are multiple examples of this. The UK no longer has access to those agreements, so it no longer benefits from that relationship between the EU and that third country. It would always be, as Gemma mentioned, an indirect relationship in the sense that Europol actually has access to some of that data, and we would have access to Europol data.
Mm-hmm. Mm-hmm. That's very interesting. If you have any further follow-up on that point about third
we would be happy to
countries,
provide them to the committee.
I'd be really interested in, and I'm sure the rest of the committee would be as well. So thank you.
Thank you very much. Rona Mackay.
Thank you, Convener. Good morning, and thank you for coming, and thanks for such a detailed and informative report. There's just an awful lot in it, just trying to process it all. But that was a really interesting point that my colleague made there, and your response to it. So, yeah, any information on that front would be good. So it seems to me that, you know, that there's a whole bureaucratic sort of morass opened up through this, but that there are steps being taken to try and improve the situation, you know, make the best of what we have to have that done. So, I mean, I know that there's no such thing as a typical case. I mean, I get that. But do you have any indication or data on how much longer it's taking to actually process a case since Brexit?
That is a really good question, and one which we wish that it was easy to answer. Yeah. As we alluded to earlier on, it is quite difficult to prove a negative, so it's quite difficult to say, well, we should have had this information, which we haven't, and that the consequences of that are. It would be really more for operational agencies. Yeah. That sort of data would not be available to the public or to academics. But there should really be data on, for example, how long extradition cases are taking, how many refusals, and that would help to really, I think...
To complete the picture.
Yes.
I think that data would be really useful, but you're right, probably directed to those that are operational with it. Yeah. The other thing you said, one of the many things you said that interested me was when you talked about, you mentioned Germany and the issuing of warrant, and if Germany didn't reply or something, then it came to, we got the chance. Is that kind of more or less what you said? It came to us to...
So Germany has a nationality bar. Yeah. But we can issue warrants to other countries within the EU. So if that German national were to, for example, be on holiday in France, they could be picked up on a TCA warrant which had been issued by the UK. Right. That would then be dealt with by France. But firstly, France would reach out to Germany to say, would you like to issue a European arrest warrant? And if they would, that would take priority over the UK trade and cooperation.
Is there
warrant.
any reason why Germany is an outlier with that, or in Europe?
Well, so there are 13 EU member states who have similar nationality bars. Oh. That comes from, historically, it's a common law versus civil law difference. So in civil law jurisdictions, traditionally, they've had a protective approach to extradition, which is that they won't extradite their own citizens, but they do have very far-reaching laws that allow them to prosecute them in their own state. Whereas the UK position has always been that we will extradite even our own nationals to other states, and we're much more conservative in the way in which we prosecute conduct which has happened outside of the UK's territorial boundaries.
Yeah, I understand. And again, this may be for operational people to answer, but is there any particular category of crime that the new circumstances are affecting more? And, you know, is there anything that's beginning to get clogged up? You know, I'm thinking about maybe child contact cases, anything like that, because of this?
We have not been told of any one particular area of crime which we can identify to say this has been impacted significantly more than others. We have looked across different crime areas. We think we can identify some areas where there has been significant loss of access to a European agency, for example, that was considered to be very useful in that area, and we've, I think, highlighted one in cybercrime. One in drugs as an example. Okay. So I think that, but we weren't able to pinpoint and say this one particular crime area is much more significantly impacted than others.
But again, there will be answers to that from people who are dealing with it on a daily basis. Yeah, that's fine. And just sort of lastly, I mean, do you see the situation vastly improving as we go forward? I know that things have been brought in, as you've explained, to try and you know, to try and help us work together as much as we can. But is there going to be much change, do you think, over the next, say, decade? Or?
I think for me, I think there's two sort of contrasting pictures. One is that police and judicial cooperation gets lost amongst everything else that is very important in the TCA and also has to be dealt with, to do with trade and other aspects of the agreement. And so there is an argument to say, well, things are okay. The wheels aren't falling off. There's nothing, you know, the TCA, Part 3 of the TCA is operating, and therefore it gets left behind because it's subsumed by other more important areas. Yeah. But then on the other hand, we do see that this is an area which is highlighted. Security is the second of 3 of the UK's pillars for its UK-EU reset. Inevitably, organised crime will continue to develop and increase new ways of operating transnationally. Organised crime does not care about the UK's position inside or outside of the EU, and so those drivers operationally will continue. And so I would hope that we can listen to operational those in operational positions to tell us what they need and to be able to overcome those political difficulties to make progress. That's obviously well beyond my remit. Whether that can happen or not.
And I mean, I think every country internationally would want to work together to combat crime, and there's no reason not to, other than the rules that have been put in place. So I think that they would always try to be as cooperative as they could be within the rules. And I just wondered if you saw any new openings, you know, coming up that might sort of lessen the amount of bureaucracy and having to go through someone, you know, third party to get to something and everything. I mean, that just sounds so onerous, you know, for people trying to get important information.
Politically, I think we need to actually be realistic about what can be achieved. The messages from Brussels are very clear. There is a scope, there is a margin for some improvements, but it would not be able to address all the recommendations that we actually have brought to the committee today. There is a clear message, whether that is rhetorical or not, that actually the EU now needs to actually address other priorities that it has. So the relationship with UK continues to be very important, as Ursula von der Leyen has recently actually highlighted, but there are many other relationships that the EU considers to be important as well. And it's currently focusing on those relationships as well, not just on the UK one. And so we have to be realistic about what can be achieved. Having said that, we do know that actually there is an opening to actually improve certain parts of the TCA. And so it is really about identifying what can be actually achievable through this review in 2026.
Okay, thank you. That's really helpful. Thank you.
Thank you. I'll maybe bring in Liam Kerr, and then I'll finish with a couple of final questions. So, Liam.
Very grateful. Quick question for Helena, please. During your presentation, you said that we need to develop the necessary technical capabilities with a view to sharing vehicle registration data with the EU. So this is, I think, slide 6. And then you also go on to, we need to negotiate access to the ECRIS TCN system. Helena, do you have a sense of how challenging these capabilities would be to develop, and whether it would be challenging and or costly to negotiate that access?
In terms of the necessary technicalities to be able to actually share vehicle registration data, we were given limited information. We were told that actually it is not happening at the moment, that actually the UK is working on the necessary technology to be able to do so, but we haven't been told exactly what timeline we're looking at and what exact technical issues these are. I don't know if Gemma wants to add anything at this point. So we would be more than happy to actually chase this issue up with the interviewees that we've talked to, and to actually inquire whether they would be happy to provide further detail on this.
I'd be grateful. Thank you.
Okay, thank you very much. Just a couple of final questions from me. I wonder if I can go back, Gemma. We spoke earlier about nationality bars, and just note recently that the National Crime Agency told the House of Lords that currently about 10% of extraditions are now being refused because of nationality bars, which pre-Brexit would have probably been successful. So I just wondered if that is something that, obviously you've specifically mentioned it as a kind of key area of focus. So I'm just interested in what, if any, further kind of view you have on, in terms of the Parliament here, what sort of scrutiny we can perhaps undertake or offer in terms of this particular issue.
I think, firstly, it is important to ensure that that data is being collected, that we know that doesn't have to necessarily be public, but that we are very clear that we know how many cases we have been unable, and what those types of cases are, so that we can understand the impact. Because on one hand, you could argue, well, in 90% of cases we have been able to surrender the individual, but there might be, even within that 10%, there will be, perhaps cases where there are individuals that pose a significant risk, that as a result have escaped criminal justice systems. So it's important that we understand that information, and that we then work towards how we overcome that problem. We talked about transfer of proceedings being one. We talked about transfer of prisoners or other agreements. So I think that that's where we need to make sure that Parliament is very clear about the fact that that is a significant operational loss or a difficulty which is being caused, that it will be resulting in impunity for serious offences. And that we do need to be working with our EU partners to try and ensure prosecution where it is possible to do so, by whichever means.
Thank you. And my final question goes back to a point I think, Helena, you made towards the end of the presentation relating to the TCA review and I think the forthcoming summit that's taking place next month. And I think you said that the likelihood is that the focus will be on defence. So that made me think about the importance of what we've been looking at today in terms of, UK-EU cooperation, but ultimately we're looking at public safety, national security, and potentially, stepping into areas that we would think of as sitting within the defence space. So I suppose my question is, how important is it that we make as good progress as possible within the review of the TCA, acknowledging its, in terms of judicial cooperation, but its importance in terms of, the wider sort of defence challenges that we're facing across Europe.
Thank you. The agenda for the summit is not public yet. It will be made public a week before the summit. But we believe that actually it would be very important to try and actually flag criminal justice issues as being necessary to be on the agenda. There are clearly overlaps between the defence area and the criminal justice area. So if we look at what's been announced in terms of UK government intentions, in terms of a possible future agreement on security and defence, we will see that actually there's areas related to conflict resolution, operations, military operations, access to EU defence budget, which would actually always have an impact on addressing organised crime abroad, for instance. If we look at the existing EU military operations, they often have hybrid goals in terms of addressing criminal activity in specific locations. And so there would always be an intersection of these two areas. So in a way, we would argue that actually it is not really possible to just discuss security and defence, an agreement that is separate from criminal justice, because there would always be implications for the criminal justice dimension. And so this is really important to highlight this and to try and actually highlight the importance of discussing criminal justice at the summit as well.
Thank you. That's a really interesting answer, so thank you for that. Okay, if there are no more questions, thank you both very much indeed. I think that's been a really fascinating session, and we look forward to receiving your follow-up, and obviously the committee will likewise consider what next steps we can look at. So with that, I now formally close the meeting. Thank you.